After your answer is filed, it's now time for the parties to engage in what we call discovery. Now, discovery is what happens when the parties are trying to find information out about their case, find information out about each other. So this first step of discovery does not apply in every state. It's called initial disclosures. So some states require initial disclosures, some do not. What you need to do is you need to pull up your court rules and you need to see, do my court rules say anything about initial disclosures or disclosures? So both parties in a state that has initial disclosures have the obligation to provide to the other side information they have about the case right up front. So the plaintiff is going to send these to you, and you're going to need to send a set to the plaintiff's attorney. But basically, when it comes down to initial disclosures, you're really, in a debt collection case, needing to disclose two things. The first is, who are your witnesses for your case? The second is, what documents do you have? Now, in a debt collection case, it's common for the debtor, that's you, to not have any witnesses but yourself. But it could be a spouse or a friend or a parent, somebody who has information about your debt. So think to yourself, if I had to go to court today and explain to the judge why I don't owe this debt, who would I bring to corroborate my story? And then you're going to list all those people as witnesses. You're also going to include yourself as a witness because you are going to be the key witness in your case. Now, as for documents, you may or may not have documents. Maybe you have receipts that show you paid this debt already, or you paid part of this debt already. Or maybe you have, some other type of documentation. Maybe if it's a medical bill, you have, some medical records that show that the procedure they're claiming wasn't done, or that they've billed it improperly, or an explanation of benefits form, something. Just think about, if I'm going to go to court today and tell a judge why I don't owe, what documents am I going to bring in order to prove that? Then you're going to list those documents on your initial disclosures, make copies, and then send a copy to the opposing attorney. Some courts are going to want you to file your initial disclosures, and some are not. So again, check your court rules for how to deal with filing the initial disclosures. Again, probably a safest approach if you can't figure it out is to just file them. But you want to make sure you definitely send a copy to the opposing attorney. Again, you're going to get from the opposing attorney an initial disclosures that's going to include their witnesses as well as their documents. Now, this is going to be a key time for you to evaluate the case because you'll recall that they have the burden of proof and they've got to prove that you owe the debt and that they own it. So you're going to look at, well, what documents do they have? Have they given me the original agreement? Have they given me the itemized statements? And if they haven't included them in the initial disclosures, now you've got to think to yourself, they may not have them. This may not be a winnable case for them because they haven't provided those documents. Because it's often for states that have initial disclosures for the rules to also say that if you don't disclose a document in initial disclosures, you can't use it at trial. The other thing to note as far as the witnesses go is when you get to trial, you can't just show up at trial and hand the judge the original contract and the itemized statements and, the contract, but with the third-party debt collector and say, look at these, judge, rule in our favor. You have to present evidence through witness testimony. And the witnesses are going to have to testify that, yes, they have knowledge of these documents, they've reviewed the business documents, they're familiar with them, they are accurate representations of those agreements, and then they can get admitted into evidence for the judge to consider. So think about this. An original agreement. Who's going to have to testify that the original agreement is real and true and accurate? It's probably going to have to be an employee of the original creditor. Now, if you're being sued by a third-party debt collector, you are going to be thinking about, well, who can testify that the contract between the creditor and the collector is an accurate contract, that is a true copy of it? Well, that's probably going to be somebody from that works for the third-party debt collector. So think to yourself, how likely is it that they're going to bring these people to trial, and have they listed them as witnesses on the initial disclosures? If they have not, then they either are going to have a hard time getting those people to trial, which means they can't win their case, or they haven't thought this through that they need to do this, which is also going to make it hard for them to win their case. So you're kind of watching when those initial disclosures come in to say, how strong of a case does the plaintiff really have against me? And so if they don't have those documents, if they don't have those witnesses, you can feel a little bit more confident that you could win your case moving forward.